Joining us right now is civil rights attorney and host of the Leo Terrell, America's Fair-Minded Civil Rights Attorney podcast, the one and only fair-minded civil rights attorney, Leo Terrell. Leo, good to talk to you, my friend.
Larry, glad to be on the show. Thank you very much.
The trial is underway. Opening arguments happen. We got witnesses today. First of all, based on what you've witnessed in Minneapolis with regard to the seating of this jury and with regard to the opening arguments, what's your initial, before we get to today's witnesses, which is compelling, what is your overall assessment about where this trial is going?
Well, it's two arguments, two logical arguments. It's going to be the battle of the medical experts as to the causation of the death of George Floyd. And it's going to be the battle of the police experts as far as whether or not the police tactics were used properly or improperly. I think the prosecution is relying on the 9-minute videotape. The defense is looking at the totality of all the things that occurred that day, and the defense is looking for one jury to say, I don't buy the argument. They're looking for a hung jury. And the prosecution, I think, has to make sure they don't overplay that 9-minute tape so that they will numb the jury a la Rodney King trial number 1.
That's an interesting observation. The more you play it, the less horrific it seems, right? And
Absolutely.
Therefore, yeah, that's interesting. And talk to me about what is incumbent on the defense to show or prove in terms of the rationale for using force. In other words, how far do they have to go to actually show, listen, they had to use force. Now the question is what force was appropriate. You know what I mean?
Exactly. Well, first of all, you look at what events occurred prior to the kneeling on George Floyd's neck. George Floyd was disrupted. It took 3 officers to bring him down. He fought against it. When I say fought, he resisted. There was an eyewitness thought he was out of control. So the other officer's testimony and the videotape is going to show the jury how disruptive, how uncooperative George Floyd was. More importantly, there is a prior incident involving George Floyd of a similar conduct a year ago that the judge has allowed to be introduced in this trial. That is to show, on the defense side, a pattern of disruptive behavior on the part of George Floyd. The key here, Larry, is very simple. The defense, all they need is one juror not to buy the argument that the ultimate causation or substantial factor to the death of George Floyd was the officer kneeling on his neck. That will be coupled with the defense medical experts who are going to say he did not die due to the kneeling of the placement of the knee on his neck.
Talk to me about where you think that might be headed in terms of, I'm guessing there, as usual, Leo, we'll have 2 dueling medical experts. One will say, absolutely, this was all due to the kneeling on the neck. And the defense expert will say, well, that's not sure. He had a lot of drugs in his body. He had a history of medical problems. Does that end up being a wash, or does it really depend on how compelling these medical experts are?
It's the latter. It's the credibility of the medical experts in the eyes of the jurors. The jurors can discount the expert. It depends on how they present their case. And, Larry, that's where you have what you call a factual dispute. Remember one thing. The burden of proof is on the people beyond a reasonable doubt. A tie goes to the defense. So anything less than a convincing argument presented by the prosecution is a win for the defense.
Let's get back to, I think, what you have said, and one of the most important parts of this, and that is the charging or overcharging in this case. Derek Chauvin, the officer in Minneapolis, is charged with second-degree murder, third-degree murder, and second-degree manslaughter. What leeway, usually, Leo, does a jury have in terms of juggling these sentences and sort of, okay, he's not guilty of that, but he is guilty of this? Does that happen very often, or is it usually guilty across the board, not guilty across the board?
It's the former, Larry. I'll tell you right now, there's a lot of horse trading going on in a jury deliberation room. You will have a hung jury on a particular cause of action, and you might get a consensus on a lesser degree charge. And that is the battling. That's the jury deliberation process. And that goes on back and forth because some people are convinced by a presentation by the prosecution, and others are convinced or impressed by the presentation by the defense. And so there's a lot of back and forth. I believe that a second-degree murder charge is way too excessive. It was a politically motivated charge because they're trying to prove intent. I'm going to be very clear. I think the force, in my opinion, was excessive. But do I believe that officer intended to kill George Floyd? Absolutely not. The excessive force, the manslaughter charge, the lesser included charges, to me, are the charges where I think if there's going to be a verdict of conviction, it's going to be on the lesser included charges.
Yeah, from my untrained, so I'm coming at this from the perspective of not being a cop and not being a lawyer. So I'm just looking at this, as most of us are, as just a human being, an American citizen looking at this. And yes, the initial reflection is that this seemed excessive, Leo. I'm with you, and it all comes to me. It all comes down to 9 minutes. Talk about how important that part of this is. 9 minutes the officer had his knee on. At what point does a jury look at that and say, listen, I understand having to restrain him, I understand having to keep him down, but here he is for 9 minutes and he's sitting there with his hands in his pockets. You know, that do you think the trial comes down to that?
I think it's going to be, Larry, and this is where a major factor is key. All attorneys are not equal, and it's the presentation of these facts and how they present it to the jury. For example, if I was the attorney for the prosecution, you know what I would do? I wouldn't play the film. I wouldn't play the video. I would say, I would play it, but I would not keep playing. I would do this. Your Honor, I would like to now have a silence of 9 minutes and 23 seconds for a demonstration of the length of time the defendant had his knee on Mr. Floyd's neck, and let that room be silent, and let the people realize how long that time is. That's a strategy move. That's what I would do in lieu of showing the video over and over again. That's significant because that is going to drive home to the jury that maybe there could have been an alternative other than placing his knee on the neck. And that, to me, would be a driving point to really bring home the 9 minutes, in my opinion, was excessive.
Leo Terrell is our guest. Of course, you can get his podcast. It's got a great name. It's the Leo Terrell, America's Fair-Minded Civil Rights Attorney Podcast. I don't know where you came up with that, Leo. But he is a civil rights attorney. And Leo, you've tried similar cases. I mean, in your history. Talk to me about when this comes down to training, because we keep hearing that this is a question of training or lack of training. And is it incumbent on Derek Chauvin to be able to pull out a manual or pull out some kind of outline from a training program that says, oh, yeah, this is exactly what I was taught to do as a police officer? I mean, short of being able to show that, it's kind of hard for him to make a defense that this is just all in the line of duty as a cop.
Oh, Larry, you're spot on. He has to show, and it was permissible to use the knee. They were talking about a hobble restraint. So his application of his knee on the neck is a police policy practice that he was trained in. That is critical. And when I heard the prosecution mention they're going to bring an expert in from Los Angeles, I'm scratching my head saying, wait a minute. You better bring in an officer from your police department either to say that's not acceptable, but by you going to the back door and hiring someone to say it's inappropriate, that's a no-no. I found that as a weak point in the prosecution's case to make a hired gun to say this was unjustified.
Leo, there could very well be a juror who listens to all of this, listens to how cops are trained, observes the whole thing and knows what the appropriate protocols are for a police officer, watch it, and also agrees, God, that 9 minutes and 23 seconds is excruciating, especially if you force them all to sit in silence there, counselor. That's emotional turmoil you're putting them through, Leo Terrell. But I guarantee you that there will be a juror who sits here and says, listen, I get all that. But if he had just complied with the law officer in the first place, done what we're all supposed to do, which is follow a lawful command and not resist, and not get yourself into this situation where they have to use force against you, he would still be alive today. Will a juror have the freedom within the judge's instructions to sort of make that argument and say, listen, if he had just done what he was told, he'd still be alive?
Oh, absolutely, Larry. And let me tell you right now, that's an excellent point. That is going to be the reason why I believe there could be a hung jury on some of these charges. The key here is this. You have to match the wrong with a appropriate charge. And there may be a disconnect. Some of these jurors may feel, hey, the officer was wrong, but it doesn't warrant a second-degree murder charge.
Yeah, it's not murder.
It doesn't warrant a third-degree murder charge. So there may be a disconnect. And that may be the problem that some jurors will have. And they said, well, we thought he did something wrong, but we had to follow the judge's instructions. We had to follow the jury instructions, and we could not match the wrong with the charge that we were given. And that's going to be a key. And I think, Larry, I want to make 2 points that is very, very important.
Yeah.
One, I felt this jury should have been sequestered because, you got people out there. This thing is going worldwide. Yesterday you had Ben Crump, Al Sharpton holding a press conference, playing the race card outside. This jury is inundated with all this nonsense that has nothing to do with the trial inside the courtroom. We're not trying this case in the court of public opinion. This case has to be tried in the courtroom, and these jurors cannot be tainted with outside pressure.
Well, and to that end, let's wrap this up by it's funny, we've spent all of this time, Leo, you and I, over 10 minutes now, talking about the law, talking about strategies in the courtroom, talking about how the jurors are reacting and the facts of the case. Sadly, I'm afraid at the end of the day that none of that will matter.
You're right.
With regard to the reaction on the street, the way the media is covering this and the way politicians and other people, like you mentioned, Crump and Sharpton, are exploiting this situation. Anything short of a conviction, Leo, you tell me. I mean, are we doomed for another round of violence if the jury does not come back and give the verdict, regardless of the facts, if the jury does not come back with the conviction that is being demanded right now by all of those people?
Larry, I'll go one step further. I think you're going to have some, I'll use the term problems, regardless of the outcome. Regardless of the outcome. Really? Either in form of celebration or anger and disgust. I think that these cities during the summer are going to have some problems after the outcome of this trial, regardless.
Well, God help us all.
That's a state of affair, but I think that's what I think is going to happen.
Well, Leo, this is frankly where you come in, because you're able to speak in a very I don't always agree with you, Leo, but you are a sincere voice in these matters, and I wish more people would stop for a moment, take a breath, and listen to you, and actually recognize that your heart is in the right place, and you want justice. You have a long career of wanting justice as much as the next guy, but you know that justice doesn't come at the end of an arson's torch or a looter's broken window, and
correct.
And that's why your voice is so important, Leo.